Can I have your name at the jail, please? Why am I not able to hear you? Can I have your name again, sir? I didn't hear you the first time.
Tyler Hassel.
All right, Mr. Hassel, my name is Judge Hesselink. I'm coming to you from the district court. I'm going to arraign you today, so let me call your case and we'll get started with that. This is the state of Michigan versus Tyler Hassel, file 26-44389-FY-3. I'm joined by Mr. Larry Brown as defense counsel.
He's not my lawyer. I have a lawyer already.
Well, he's here for purposes of arraignment. There's no problem with you having a lawyer later, but he's just here to make sure that your rights are protected today. Okay.
Well, I don't trust Larry Brown. I'm sorry.
Mr. Hassel, you're not asked to trust Mr. Hassel. You're not asked to trust him. He's just simply here to monitor to make sure that I do what I'm supposed to do.
Okay.
And you don't have to do anything.
He's not my lawyer, though. I want that on the record that I did not hire him.
You already said that. You don't have to repeat yourself, sir.
Okay.
What you're here for is an arraignment. So I'm going to tell you what you're charged with, tell you what your rights are, and then we'll discuss bond. So listen carefully, please. This is a complaint filed by the Attorney General's office. It has 4 counts. They're all of the same type of activity, but different time frames. So count 1 reads that on or about October the 1st of 2021 through February 28th of 2022, within the city of Gaylord and Otsego County, that you did commit the offense of child support failing to pay, in that you did not pay support for your children in the amount or at the time stated in an order entered by the Otsego County Circuit Court in file number 2017-16873-DC. That is contrary to the Michigan compiled laws. That is a felony offense. It has a maximum possible penalty of 4 years and or a $2,000 fine. You understand the name of count 1?
To a point.
What don't you understand?
Well, I've made $8,000 plus in payments last year, and probably more than that. It hasn't even been 8 months since I made payments, so I'm confused how I paid $10,000.
Okay, Mr. Hassel, nobody said anything about $10,000 or what your payments were. I simply told you what you're charged with, not whether that or not you actually did it. My question is not, did you do it? My question is, do you understand the name of the charge that's been made against you?
Honestly, I'm autistic, and I understand it a little bit, but I don't.
All right. The allegation is that you owe child support and you failed to pay. Do you understand that?
I understand that's what I'm being accused of, yes.
All right. Do you understand that the maximum possible penalty for that offense is 4 years in prison and or a $2,000 fine?
I do now, yes.
All right. The next count 2, reads exactly the same way, but it has a different time period. So let me read that to you. That says in count 2 that on or about May 1st of 2022 through March 31st of 2024, you did commit the same or similar offense, failing to pay your child support, in that you did not pay support for your children in the amount or at the time stated in an order entered by the Otsego County Circuit Court in file number 2017-16873-DC. Again, contrary to the Michigan compiled laws, that also has a maximum penalty, is a felony, has a maximum penalty of 4 years and or a $2,000 fine. Do you understand the name of count 2?
I'm a little bit incompetent and autistic, I'm going to be honest. I feel like I'm being entrapped right now.
Mr. Hassel, nobody's entrapping you. I'm simply giving you information. Entrapment is something that the police do, and I'm not a police officer, I'm a judge. So my job is to tell you what the name of the offense is, and I've told you that this is failing to pay child support. That's count 2 or the second charge, and it has a maximum penalty of 4 years in prison and or a $2,000 fine. Do you understand the name of the offense being failure to pay your child support?
Yes, but I don't understand why.
I'm not here to tell you why today. That's something that you can discuss with your lawyer, and that'll happen in the future. All we're going to do today is tell you what the name of it is, tell you what the worst thing that can happen, how much the prison time is, how much the penalty is, and all I want to know is, do you understand those 2 things, the name of the charge?
I do now, yes, Your Honor.
Actual penalty. All right. We're going to do this 2 more times. Okay. There's 4 total charges. We're going to do it 2 more times. So count 3, the same charge, the same name, the same penalty. Do you understand that?
Yes, Your Honor.
Right. The time frame has changed, and that is in count 3 that it's between August 1st of 2024 and November 30th of 2024. So that time frame is the only thing that's changed. It's the same name, child failing to pay child support, same penalty, 4 years and or a $2,000 fine. Do you understand the name of count 3?
I do now.
You understand the maximum penalty for count 3?
I do now, Your Honor. Yes.
All right. Count 4, the last of these charges, is again, same name, same substance, same penalty, but a different time frame. That time frame for count 4 is between March 1st of 25 and July 31st of 25. But it has the same name, failing to pay your child support, the same information in it that you've violated the court's order by not paying your child support as ordered, and it has the same penalty, 4 years and or a $2,000 fine. You understand the name of count 4?
Your Honor, they were taking $1,000 a week out of my paycheck all through 2025. So how did I not pay?
Mr. Hassel, again, we're not here to talk about what actually happened. That's for a later date. So what actually happened is not what we're here for today. This is only what you're charged with. This is what they say that you did.
What I have
we'll
to
talk
defend.
about whether or not you actually did it later. Okay?
Okay.
So do you understand the name of count 4?
Yes, Your Honor.
Do you understand the maximum penalty for count 4?
Yes, Your Honor.
All right. I also want you to listen. So we've talked about what the charge is. I want you to listen to what your rights are. And again, nobody's going to do anything today about these rights other than decide whether or not you get a lawyer. So we're going to postpone everything else for a later date for afterwards. All right. So these are the rights that you have right now that will continue until you tell me that you want to do something different with them. You have the right to have to plead guilty, not guilty, or to stand mute. You have the right to be represented by an attorney, and if you can't afford an attorney, one will be appointed for you. You have the right to have a trial by a judge or by a jury. If you wanted to have a trial, you'd also have the following trial rights. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to get an order from the court called a subpoena to require those witnesses to appear and testify. You could present your own witnesses and evidence. You could testify yourself, or you could choose to remain silent. And if you remain silent, that could not be used against you. That's your right against self-incrimination. At trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would always remain with the prosecutor. You don't have to prove anything. You'd also have the right to automatically appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
The best to my mental capacity, yes.
All right. And you're going to have a chance in the future to talk all of those rights over with your attorney as well. Do you have any questions right now for me about those rights?
Honestly, I don't. I just got out of jail less than 2 months ago. I had a warrant 15 days after I got out, so I'm still trying to figure out how this is all even a thing.
All right. So we'll let your attorney help you with that. Right now, I just want to make sure that you have heard what your rights are, and you can discuss those with your lawyer later.
Yes.
So you've told me that you want to retain your own attorney. Is that correct?
That's my intentions right now. And the FBI and everybody are involved in this case, and they're watching it very hard. And so I think I need to communicate with the FBI on what they're going to do, because they're monitoring my case extremely for the last year, and they see everything that's being done. So,
okay, Mr. Hassel, all of that is well within your rights to do if you wish to. So I'm not going to stop you from talking to anybody if you want to. Do you have the name of your attorney already in mind?
It's in the works right now. It's not going to be from around here, though.
All right. Well, I want to make sure that you have sufficient time to get that attorney. How long do you think that you're going to need?
Well, I just got in here a couple days ago, so I have to still call and I haven't had a phone for the last 3 days. They just got the phone working this morning, so I'm a little behind on getting everything figured out.
All right. Well, here's what I'm going to do, Mr. Hassel. There are some court hearings that I need to set in order to protect your rights. So I'm going to give you some time to find your own attorney, but I want to tell you when those court hearings are going to be so that you can plan accordingly. There is what's called a first hearing is called a probable cause conference. That's for you or your attorney and the prosecutor to discuss the case to see if there's a way to resolve the case quickly. That will happen within the next 7 days. There's also what's called a preliminary examination, which is a short hearing in district court in front of me as the judge, where the prosecutor has to bring in witnesses and evidence to show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That will happen within the next 21 days. You can adjourn the preliminary examination if you wish with my permission, but you have to ask for that, and we'll do that in the future when we set some court dates. So you've got at least 7 days to find an attorney. If you can't do that, then you would have 14 more days after that to find a lawyer, and we will have a status conference relatively shortly before the preliminary examination. So I'll ask you again whether or not you've gotten an attorney. And if you need more time at that next court hearing, I'll probably give it to you, although I will say we need to move things along in a little more hurried fashion. Does that make sense so far?
Yes, I'm entitled to a speedy trial. I do know that.
Yep. So we'll keep working at that. So right now I'm going to enter a not guilty plea on your behalf in order to protect all of your rights until you have a chance to speak with your attorney.
Thanks,
you understand or have any questions about any of that?
No, not at this moment.
All right. What we're going to do next then is we're going to consider the issue of bond, and that's how you would get out of jail if you're able to do that. So I'm going to ask Mr. Brown, because he's here to help me with that part of this, to give me any comments that he has, and then I'm going to ask you if you have any additional comments after listening to his. All right, Mr. Brown, your thoughts.
Your Honor, not having had an opportunity to speak with Mr. Hassel, it does appear, based upon some of the statements he's made, that he is working. Maybe they're taking some things out, a withdrawal order. So I would ask court to take that into consideration when setting a bond, especially if he is working and there are payments potentially at least being taken out. We don't have anybody here from the FOC, so I don't know exactly what the total arrearages are. I do know what the court does as far as initial bond, but I would ask the court to consider that and anything else Mr. Hassel has to say as far as his work situation in particular.
All right. Mr. Hassel, the only comment that I'm going to make to you about what you can or should say is I don't want you to make any statements about the facts of this case because we are recording this and it could be used against you later. However, if there is anything about bond, which is really when you're going to show up and why you're going to show up and what money that you have to use to show up, and if there's anybody that will vouch for you or say, yes, you have ties to the community, that's what bond is about. You can tell me about those things. I'd be happy to listen. So this is your opportunity, sir.
Well, I just got out of jail, and my bond was $10,000. Like, I got out less than 2 months ago. I sat 5 weeks in here, and I had a job all last year. They were taking the money out of my checks for over a year. They probably took over $10,000 from me last year. And then I lost my job.
Mr. Hassel, you're telling me about facts of the case, and I said you probably don't want to do that.
Okay. All right. I just need to get out and try to get a job. When I got out of jail 2 months ago, they told me to get there. I've been communicating with the court every week, following their orders for the last 2 months. I communicate with them every week. Shasta writes me back. I send my job searches. I take my kids 3 days a week right now. The courts don't know that I have my kids back, but the mom and I have turned and co-parented together, and we've went against, and we've conjoined and resolved and discovered that it's best that my children are back in my life. And I need to get out so I can be a dad, and so I can try to get a job, so I can try to get this issue taken care of. And me being in here fixes nothing. It just makes me farther behind.
Thank you, Mr. Hassel. The statute for failing to pay child support has a specific part of it that deals with bonds. and it limits what the court can do on these bonds in the initial setting of the bond. And it says that I'm to set a cash bond equal to 1/4 or 25% of what the amount that is owed under the child support order. And the friend of the court has, or the Attorney General's office that brought the charges has indicated that there is due and owing an amount of $29,770.56. So the 25% of that would be $7,442.50. So I'm required by that statute to set that as the initial bond. Your lawyer can make a bond motion at a subsequent date, that is after this, and say there are some circumstances under which you might qualify for a personal recognizance bond or a lowering of the bond, and I can consider that then. But in the initial setting of bond, I'm required to do that. So unfortunately, that is what I'm going to be required to do. So I'm going to set a cash or surety bond in the amount of $7,442.50. The Attorney General's office has also asked that I set some conditions on that, such as no contact with the alleged victim because there's a prior domestic violence in your history. And that is typically something that the court generally does. Do you have any comments as to that?
What domestic violence is in my history? I've never been charged with domestic violence in my life.
I'm telling you that the Attorney General's office has said that.
I've never been in a domestic violence, so I don't know where that's coming from.
The Attorney General's office says that there's a claim from the victim that there was prior domestic violence.
From what victim?
That would be Michaela Bergman.
That's news to me because we've never even been to jail or court for a domestic violence ever in history.
Well, you can do domestic violence without being convicted of it.
I'd never domestic violence her. We've never been in that kind of relationship. And we civil, we talk every day. We're very, very in communication, and she's against everything that's going on right now. Because it's hurting our children. I don't know where they're coming up with the domestic violence, but we've never had a domestic violence. I've never threatened any or anything like that. Nowhere in my case have we ever discussed the domestic violence, ever.
Okay, Mr. Hassel,
I was accused of being a drug addict, not a domestic violence.
Mr. Hassel, you told me that. You don't have to repeat it. I heard you, so I'm looking right now to see if there's any other places where I have information about that, and I don't see any. So that confirms what you told me, that you've not been convicted or arrested for domestic violence. So I'm taking you at your word on that. So here are the conditions of your bond. You must personally appear for any scheduled court date. You must abide by any judgment of this court. You may not leave the state of Michigan without the permission of the court. You may not commit any crime while on release, and you must immediately notify the court in writing of any change of address or telephone number. You may not use alcohol or illegal controlled substances while you're on bond, and you must participate in a substance abuse testing or monitoring program at the discretion of Community Corrections. That's the agency that monitors people that are on bond for this court. I'm not going to grant the no contact provision. I will say that there is to be no assaulting, harassing, intimidating, beating, molesting, wounding, or threatening of Michaela Bergman. That just means
I'm not that person.
Right?
I'm not that person, Your Honor.
And I'm going to put down, they've requested that you not have any contact with her or not be within 50 feet of her. I'm not going to enter that as an order of the court, given the information that you've given me.
Your Honor, so if she goes up there and waves this like she's done in the past and waves this down, does this, she's already going up there. Okay.
Mr. Hassel, I can't give you any legal advice. I'm the judge,
Okay.
so I can't give one side or the other side
I got you.
legal advice. That's a question that you need to talk to your attorney about. I will say that you will be required to contact community corrections if you are released from the jail, if you pay the bond, and the jail has the information about how to contact community corrections because they are the people that monitor those who are out on bond for the court. Do you have any questions about bond?
No, because I know I'm not gonna be able to post it. I couldn't post 10,000. I can't post 7. I haven't even been out of jail for 2 months.
Then what you're
I
going to
haven't
need to
even
do
been
is
able
to
to.
contact your attorney and ask your attorney to bring a motion in front of me at the next court date or before if they think that that's necessary. And I can reconsider things at that time. But today I'm stuck with what the statute says. All right, sir? Thank you very much.
I understand, Your Honor.
That's all for today. Good luck to you, sir.
Thank you.
Deputy, could I have Richard Ayat, please?
Yes, you may, Your Honor.
The defendant, Tyler Hassel, appeared in court facing 4 felony charges for failing to pay child support. During the hearing, he repeatedly claimed money was already taken from his paychecks and even said the FBI was monitoring his case. The judge stayed focused, explaining that the arraignment is only about charges and rights, not arguments or defenses. Things escalated as the defendant continued bringing up facts and confusion, despite being warned not to. In the end, the judge set a strict bond of $7,442 based on the law, leaving the defendant unable to pay. And that's what happens when you argue facts at the wrong stage of a courtroom process. If you enjoyed this case, hit like and subscribe for more courtroom drama. This case highlights a common and critical mistake often seen in sovereign citizen-type behavior, the belief that individuals can selectively follow court orders or override legal authority through personal reasoning. Several defendants in this footage openly ignored instructions, interrupted proceedings, or attempted to justify violations based on their own interpretations of fairness. The judge's response was consistent with established legal principles. Court orders must be followed regardless of personal agreement. One key takeaway is that intent does not excuse noncompliance. Even when a defendant argued that contact was initiated by another party, the court emphasized that the restriction itself was absolute. Violating it under any circumstance remains a violation. Another important principle demonstrated here is courtroom procedure and representation. When defendants speak out of turn or attempt to control their own narrative without legal strategy, they often harm their own case. The judge even pointed out that trained attorneys know how to present arguments effectively, reinforcing the importance of legal counsel. Ultimately, sovereign citizen arguments fail because they're based on misconceptions about how law works. Courts operate on established statutes and procedures, not personal beliefs or internet theories. The takeaway is clear: respecting court authority and following legal guidance is essential to achieving a better outcome.